I rise in reluctant support of this bill, of the Innovation Act. The bill addresses the issue of patent trolls suing large companies, small businesses, and retailers over vague patents and using the cost of litigation as a weapon of extortion to secure settlement fees. The bill is real, the problem is real, and addressing it is important. The bill proposes to address the problem by providing end-user defendants the ability to switch the suit to the manufacturer when confronted with patent trolls, increases transparency of patents and the companies that own them, and asks the Judicial Conference to review and amend certain discovery rules. These are reasonable changes to the current law that will help reduce the burden of patent trolls on our economy. Unfortunately, the bill does not deal with the problem of diversion of user fees from the Patent Office. Unfortunately, also, the authors of the bill have grafted the Republican agenda of so-called tort reform onto the bill. These provisions may severely limit the ability of real inventors and those with meritorious patent claims to obtain justice in our courts. They are deeply troubling and ought to be addressed by amendments to the bill now and improvements to the bill when it is taken up by the Senate. The most troubling provision is the loser pays provision. I oppose loser pays provisions in general and in this context as well. The reason is one of fairness. I don't believe that only large corporations or the wealthiest members of society should have access to justice. Already the threat of the enormous cost of litigation may act to prevent individuals from pursuing even the most meritorious civil liability claims. For most individuals and small businesses, the financial risk of having to pay the other side's costs and legal fees as well is one too great to bear, no matter how valid the claim. It is simply not fair to unnecessarily punish individuals with serious and meritorious claims for seeking justice. Keep in mind, a person or a business can have a legally legitimate dispute regarding fact and law and yet still ultimately lose the case. They shouldn't be unduly punished for trying to protect their interests in court. Furthermore, we don't want to create a situation where experienced corporate defendants with enormous resources and expert legal talent can bully injured plaintiffs into unfair settlements due to the risks associated with losing a potentially successful case.
I yield the gentleman an additional half-minute.
Thank you. I have other concerns as well when it comes to some of the bill's modifications of pleading standards. But we must deal with the real problem of patent trolls exploiting the current legal system for illegitimate purposes. We must disrupt the business model of the patent troll. We must prevent the extortion of small businesses across America. I will support the bill today, but I want to encourage our friends in the Senate to do a better job in balancing the competing interests. And I urge them in particular to insist on their version of the bill and not allow the House's loser pays provision into the final bill that we vote on in the conference report. Thank you. I yield back the balance of my time.